Okay, so imagine this. You've lived in the same place for 17 years. You're a model resident. You pay all your dues, on time, every single time. And then one day, poof, your key fob stops working, you're locked out. And the reason? It all comes down to a fight over your garage door that started 6 years ago and somehow snowballed into a $750 standoff.
Right? It sounds completely wild. So let's dive into this because it's a fascinating story about rules, about responsibility, and about, well, the mail that we decide to just toss in the trash. How does a simple paint job spiral this far out of control?
So our story really kicks off in 2019. This is when everything finally comes to a head, and we meet our homeowner who suddenly feels like a total stranger in his own neighborhood.
So this is Robert Greco. For 17 years, he's been a resident in good standing at the Bellasera community. He pays his dues like clockwork. But on July 1st, 2019, his world just shrinks. His key fob won't open the security gate anymore, and his access to community stuff, like the clubhouse, is just gone, revoked. And from his point of view, he's done absolutely nothing wrong. So what happened?
Well, to get it, we've got to go back, way back. 6 years earlier, back to 2013, which is where this whole saga begins over one teeny tiny issue. That's right, this whole 6-year legal drama didn't start with a bang. It started with a piece of paper, a simple courtesy notice, the kind of friendly reminder most of us have probably gotten from an HOA at some point. And this is the violation we're talking about. The exact words from the Homeowners Association were that his garage door was faded and needs to be repainted. That's it. That's the spark that lit the whole fuse. A simple request for a new coat of paint. But here's the thing. That simple request got zero response. And what happened next was this rapid-fire escalation that went from a friendly little note to a full-blown conflict in just a few months. Now, just look at this timeline. It really shows you how persistent the HOA was being. It all starts on February 5th with that polite courtesy notice. But then, wow, a little over a month later, March 14th, bam, final notice and a $250 fine. Then April, another notice, another $250 fine. May, a fourth notice and a third $250 fine. By June, the lawyers are getting involved. I mean, from the HOA's perspective, they were just following their own rule book, step by step. So why on earth was he not responding? Well, Mr. Greco explains it himself in a letter he wrote later on. And this right here is the absolute heart of the problem. He said he considered the notices unsolicited mail, and he just threw them away without even opening them. It was just part of his Saturday routine. The very first piece of mail he actually opened was the one from the lawyers. And as soon as he understood what was going on, he did what they asked. He painted the door on the 4th of July, 2013. But by that point, the damage was done. Those fines were already on the books. And just because the door was painted, that didn't make the fines go away. What came next was this quiet 6-year Cold War between Mr. Greco and his HOA. This was the number, $750, 3 fines of $250 each. That total was now officially attached to his account for that violation. And for 6 straight years, the process was exactly the same. The HOA would send him his quarterly bill, which included that $750 balance. And every single time, Mr. Greco would literally take a pen, cross out the $750, and just pay his regular dues. And this went on and on all the way until 2019. Then, in June of 2019, a friend of his who's on the HOA board gives him a heads up. Hey, they're about to revoke your access. So this last-ditch negotiation starts. First, Mr. Greco offers $100 to make it all go away. The board counters with $250. And then, in this kind of cheeky final move, Mr. Greco offers $251. That's $250 for the fine and $1 to rent the clubhouse. The board was not amused. They declined. And just like that, he was locked out. So, naturally, this all winds up in a formal hearing in January of 2020. And the entire case really hinged on a couple of key legal ideas that would decide who was right and who was wrong. So here's the million-dollar question, right? Mr. Greco's argument was, hey, I never actually saw the notices before the lawyer's letter. From his perspective, you can't fine someone if you didn't properly warn them. So the judge had to figure out, what does notified actually mean in the eyes of the law?
And the answer comes down to these two concepts. On one hand, you have actual notice. That's what you think it is. Someone hands you a letter, you read it, you know what's up. But then there's this other thing called constructive notice. And this is a legal idea that basically says if all the facts show you should have gotten the notice, the law just presumes you did. It doesn't matter if you actually open the envelope or not.
Let's just walk through the judge's logic here, because it was incredibly straightforward. Step 1, did the HOA mail the notices to the right address? Yep. Step 2, does the law assume that mail sent to the correct address gets delivered? Yes, it does. Step 3, does that mean constructive notice was established? You bet. And that leads to the final crucial point, step 4, it was not the HOA's legal job to make sure Mr. Greco actually opened his mail. And with that, the decision was crystal clear. The judge dismissed Mr. Greco's petition. The Homeowners Association had followed the rules and had not broken the law. So, after a 6-year fight, a court hearing, and a whole lot of drama, what's the ultimate lesson here from the story of the $750 garage door? So why'd he lose? Well, it all boils down to these key things. The court basically said homeowners have a responsibility to know what's being sent to their own address. Just ignoring your mail isn't a legal defense. That concept of constructive notice turned out to be just as powerful as if someone had handed him the letters in person. And finally, those fines were totally legitimate because they were for a violation that just kept going for months. They weren't some kind of illegal late fee.
I mean, this whole thing is such a powerful reminder, isn't it? In a world where we get 1 million digital notifications a day, it really makes you wonder, just how much power does a simple, unopened letter still have? Well, if you live in a community with shared rules, the answer might be everything.